There's a lot of confusion and misconception over whether or not a handwritten trust or a handwritten trust amendment is valid. Now, generally speaking, a handwritten trust amendment is perfectly fine. It's perfectly valid under the law. Most trusts require that an amendment be in writing and delivered to the trustee. If that's the case, the in writing part can either be typed up or it can actually be in handwriting. It makes really no difference as far as the law is concerned, as long as it's written down in some form. The only problem you tend to get with handwriting is that people aren't always clear on what they're trying to say, on what they're trying to express. They may understand what they're saying, but the language may not come out so clearly when the time comes and the children or the court or lawyers get involved and they're trying to figure out what does this language mean. So if you're going to handwrite a trust amendment, be sure that you're being very clear and concise about what it is you want to change and how you want to change it so that people aren't guessing about it later on after you're gone. Most trust amendments follow the probate code requirements that it must be in writing, signed by the settlor, delivered to the trustee. So don't forget to sign your handwritten amendment if you're going to do that. And whatever you do, do not make changes on the original trust document. There's nothing worse than looking at an original trust and seeing things crossed out and little notations added in. A lot of that stuff is going to be very hard to enforce, if it's enforceable at all, because there's no intent behind it. Did they mean to change it? Was that just a draft? Is it even signed? Half the time these notations will be made and there's no signature, and so it doesn't comport with the requirements of the probate code or the requirements of the trust document that say an amendment must be in writing and signed by the settlor. So if you're going to do a trust amendment, it's fine if you want to do it in your own handwriting, but do it with the proper formalities that the law requires, that it be in writing, signed, and delivered to the trustee. And if you're going to do it in your own handwriting, make sure you're very clear about what it is you're changing and what you want to add or subtract from your trust document.